All right, you just got served. A process server showed up at your door, or maybe a stack of legal papers arrived in the mail. Either way, your name is now on a Florida lawsuit, and your stomach just dropped. But in this video, I will tell you exactly what to do if you've been sued in Florida. And by the end of this video, you'll know the 5 critical moves that protect you and the 1 catastrophic mistake that hands the other side an automatic win before you ever set foot in a courtroom. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've guided hundreds of businesses and individuals through Florida's civil court system, and what I'm about to share with you is the exact playbook I use with all my clients when they walk through the door on day 1. All right, let's dive in. Here's what most people don't know when they get served. Being sued is not the end of the day. It is actually the beginning of a process you can control when you know the rules. I call this the Florida defense window. Understanding it is the most important thing you will do in the entire situation. The moment you are served with a Florida summons and complaint, a timer starts. Under the Florida rules of civil procedure, you have 20 days to respond. Not 20 business days, 20 calendar days, including weekends. Right now, you might be thinking, I have time, I'll figure this out. Stop right there. That exact thought is the one that destroys cases before they even begin. Here's what happens when defendants ignore the 20-day deadline. The plaintiff's attorneys file a motion for default. The court grants it. And just like that, with no hearing, no argument, and no word from you, a default judgment can be entered against you. That judgment is not just a piece of paper. It can be used to garnish your wages, it can freeze your bank account, and it can attach a lien to your home or your business property. I call this the silent loss. You didn't lose in court, you lost by doing nothing. And the worst part is, it is entirely avoidable. But here's the thing, and this is where most defendants finally breathe. The Florida defense window exists, specifically to give you time to fight back. The key is knowing what to do inside those 20 days. The first move inside your Florida defense window is simple. Read the complaint. Every single word. Not a skim, a full read. The reason why this matters is that Florida complaints are loaded with mistakes. Plaintiffs name the wrong party. They file in the wrong county, and they miss required legal elements. They get the timeline of events completely wrong. Every single one of those errors is a legal weapon available to you. You'll never find those weapons unless you read the complaint carefully. Think of the complaint as a map that the other side drew. The moment you spot where that map is wrong, that is the moment that your defense begins. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now let's get into the part most defendants miss entirely. And here's the mistake I see over and over again. Someone gets served and their first instinct is to pick up the phone and call the other side. Maybe work this out. Maybe there's been a misunderstanding. You don't want to do this. Anything you say to the opposing party or to their attorney can be used against you in court. Florida evidence rules allow a party admission to be introduced at trial. 1 phone call, 1 text message, 1 casual email, all of it becomes part of the record. I call this the Goodwill trap. It feels like the right move. It feels like the mature move, but it is one of the most damaging things a defendant can do in the early stages of a lawsuit. Save every conversation for your attorney. Now here's where your options open up. When you respond to a Florida lawsuit, most people assume they have 2 choices, fight or settle. But actually, you have 3 very powerful tools you can deploy inside your Florida defense window. And the right combination of these tools changes everything. The first tool is an answer. This is your formal response to each allegation in the complaint. You admit what is true, you deny what is not. The second tool is affirmative defenses. These are legal arguments that say, even if everything the plaintiff claims is true, you still should not be held liable. Florida law recognizes dozens of affirmative defenses. statutes of limitations, comparative negligence, failure to mitigate. These are all very powerful. And then the third tool is a motion to dismiss. This challenges whether the complaint is legally sufficient at all. If the plaintiff failed to plead a required element of their claim, the case can be dismissed before it ever moves forward. I call this combination the defense stack. When it is built correctly, it shifts the leverage in the lawsuit. The plaintiff stops driving, and you start driving. But here's the thing. The defense stack only works when it is filed correctly and on time, which brings me to the final move. This is not the moment to look for the cheapest option. This is the moment to find someone who knows Florida civil procedure inside and out. Florida has specific procedural rules that are unforgiving. Miss a deadline and you lose rights. File in the wrong court and you lose time. Respond to the wrong party and you create confusion that benefits the other side. The reason why attorney selection matters so much right now is that most of the damage defendants suffer happen in the first 30 days. Not at trial. That is when procedural mistakes are made. This is when the defense stack is built or left on the table. You didn't get served because you're a bad person. You got served because someone made a legal move against you. Now the question is whether you respond strategically or react emotionally. Those two paths lead to two very different outcomes. So let's bring this all together. When you are sued in Florida, your Florida defense window is 20 days. Read the complaint for errors. Do not contact the other side and build your defense stack. And get the right Florida attorney involved fast. The silent loss is real, but so is winning when you know what you're doing. If this video helped you understand what is at stake, do me a favor, like this video. It helps more people in Florida find this information when they need it the most. And subscribe to this channel so you never miss a video. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.